Would you like us to call the Shoneth matter early?
I would, Your Honor.
All right, we can call Shoneth v. Secretary of State. It's file 26-9208AL. Counsel, you want to state your appearances beginning with petition?
Luke Custody on behalf of the petitioner, Your Honor.
Mr. Goodrich on behalf of the Secretary of State.
All right, and this is an appeal in a driver's license matter. And I've had an opportunity to review the petition for review, the record below, as well as your brief in support of the petition. Mr. Kukuski, go ahead and make any argument you wish.
Thank you, Your Honor. Mr. Shoneth appeared before the Secretary of State seeking to have his restrictions removed that he had on his driver's license. Basically, the restriction, it was a curfew restriction that he had left on his driver's license. He had been revoked back in 2004, the restrictions that he received after the revocation, the year of revocation, were that he had the interlock in for a year, and then the, I guess, restrictions that associated with that. After a year of successful interlock, he did have that removed by the Secretary of State. He continued on the restrictions until the hearing he recently had to get those removed. At the hearing, the hearing officer found that not only was she going to keep on the restriction, but she was revoking his driver's license at that time. And so we're here to appeal that decision and ask the court for granting of his full license. The hearing officer made a few different findings to Mr. Shoneth to support, I guess, her reasoning why he should be back on the revocation. One was the interlock. There's no interlock report filed. When I did see an email that he had sent that should have made it into the record, why it wasn't, I'm not sure. I know that's not part of the record for Your Honor to decide, but her order in and of itself on the first page indicates that he was successful on the interlock. That's why it was removed. If you're not successful, that restriction is not going to be removed from you. And so, or
his revocation would have been reinstated.
It certainly would have, Your Honor. So I think that argument is without much merit. It certainly is to be an abuse of discretion. And then she went on to take issue with the statement that he made during the hearing, which asked about his sobriety. He says, working towards not drinking again. And so, in my experience with recovering alcoholics and dealing with the AA community, I'm sure Your Honor is familiar as well, it's a lifelong process. It's a lifelong commitment. And so they don't talk as to, I'm never going to drink again. They say, you know, that's my goal. And I think even later in the hearing and in my brief, I put a statement that he had said that, yeah, I hope not to drink the rest of my life. And that's my goal, and that's what I'm hoping to maintain my sobriety. So again, I think that was a misplaced reason to revoke him again. There was also testimony as to marijuana use. He did have and testified that he had a medical marijuana card. It was prescribed to him. He was honest about his use. His last use was back in July of 24. That was disclosed to the assessing agent who chose not to give any, I guess, status to his marijuana use. And so, again, it was a prescription that he had when the medical marijuana cards were. He didn't renew that prescription when it became legal. It was basically an over-the-counter prescription at that point where his doctors, well, you can get it, you can get it. He no longer uses marijuana, and he doesn't have any intention to use marijuana, but certainly I think that was, again, an abuse of the discretion by the hearing officer. And the final and last thing was the drug screens. The hearing officer indicated that his drug screen had no variables on the drug screen. And in fact, if the court looks at the record that was provided with the transcript, Mr. Shoneth did provide 2 drug screens. One, he provided. They emailed him right back and said, well, this doesn't look like it might meet the muster of the standard for the hearing officer. So he went and retested. Both tested negative for any substances, but the second one certainly did provide variables and would confirm that he was not using any drugs or alcohol because of the negative test that he received. Given his testimony, given the drug screens, his assessment, and just the totality of the information, and that he was there to remove the restrictions. He wasn't there as a trying to get just a license or on restrictions. I do feel that the decision by the Secretary of State to reinstate his revocation was not supported by the substantial evidence on their whole record. It was just clearly an unwarranted abuse of the discretion of the hearing officer. So we're here today to ask the court to overturn that decision and to grant him a full license. Thank you.
Okay, thank you. Ms. Goodrich, the secretary's position?
Oh, Your Honor, I'd ask that you find that there is not an abuse of discretion for the reasons given by the hearing officer in denying the request. One was for violating the restriction by using marijuana as recently as 2024. He did not have a marijuana card at that time. He also testified that he had been sober for 20-some years. Both of those things can't be true if he's using marijuana without a prescription. He also was not following, the second reason was that he was not following the recommendations of the substance abuse evaluation. The substance abuse evaluation was part of the court record, and the recommendation was that he continue community support groups. They provide essential emotional connection, accountability, and shared understanding, help reduce isolation and strengthen coping skills. He admitted to not attending support groups per that as recommended. The third reason was that the drug screen was not sufficient. And the fourth reason was he did not provide the interlock report. Thank you.
Thank you. Well, this court's review is, of course, for an appellate review. Not what I would have done, but did the Secretary of State hearing officer make a decision that was supported by competent material evidence on the whole record, or was the decision arbitrary, capricious, or an abuse of discretion? And in this case, the petitioner had a revoked license for a couple of drunk drivings a long time ago, and got a restricted license that at that time only had a 1-year interlock, successfully completed that interlock, and then was driving with the restriction for like 20 years. And then finally decides, I want to get rid of all restrictions, and goes to the Secretary of State to do that. He had the burden of proving by clear and convincing evidence that his substance abuse problems are under control and likely to remain under control. He presented evidence that he had abstained from alcohol for over 2 decades, supported by his community letters, submitted a substance abuse evaluation with a positive prognosis in not 1 but 2 drug screens. One of them looks like it was an instant screen at a doctor's office. And then the second one was a lab report through Redwood Toxicology, which is the same lab that this court uses as part of its treatment court supervision. And the petitioner disclosed to the hearing officer that he had a one-time he had a use of marijuana in 2024. He didn't have a current medical marijuana card at that time. It wouldn't be a violation of law, but it would be a use of an intoxicating substance without any medical reason in 2024. That would be some basis for concern, and the hearing officer noted that, but the hearing officer said that that wouldn't be a reason to reinstate a revoked license. And I agree with that statement, because by statute, Mr. Shoneth was only required to show 1 year of abstinence. He showed 20 years of abstinence from alcohol, and more than 1 year of abstinence from marijuana. From that I guess it's fair to say on this record, it was an isolated use. So I don't think that isolated use overcomes the strong evidence of 20 plus years of alcohol sobriety. Further, the hearing officer found fault for the petitioner not submitting the interlock report. But the interlock report was from 20 years previous. The hearing officer would, I mean, I think it certainly is. If the hearing officer didn't have access to the report, the hearing officer could have easily obtained access to that report if there was any concerns, or could have continued the hearing to allow Mr. Shonath to provide it. Where the interlock was removed 20 years ago, and there's a notation on the record here that the hearing officer said there were no violations. And of course there weren't, or it would have been extended, or the revocation would have been reinstated. So that's sort of an abuse of discretion to say, I'm going to fault you for not giving me the 20-year-old report when everybody knows there would have been no violations, or you wouldn't be in the situation you're in. And plus, as a hearing officer, I can get access to it, or at a minimum, I could continue the hearing if I want to review it to give you a chance to get it for me. Didn't continue the hearing, didn't even continue the restrictions. Oh, and then also the hearing officer found fault with the drug test because it was only an instant screen. Well, that the hearing officer is just mistaken about the record. There were two tests. One of them was just a screen, but the other one that's attached to the official record on appeal does have a lab report. And for the hearing officer to say, well, you didn't give me a verified lab report, that's just contradicted by the record. So based on this record, I would find that the hearing officer's decision reinstating the revoked license for Mr. Shonath was an abuse of discretion and was not supported by competent material evidence on the whole record. So therefore, I would grant the appeal and direct the Secretary of State to issue full driving privileges to Mr. Shonath. And Mr. Kukuski, you can submit an order to that effect.
I know this hearing was for later. I was going to go back to my office. My secretary said she did email the order, but that was something I was going to bring back. So
okay, great. Great. If we get the order, then we'll see if the prosecutor will approve it as to form. I think that helps things go more smoothly with the Secretary of State and get it signed.
Very good, Your Honor. Thank you, Your Honor.
Okay, thank you. Good luck, Mr. Shonath.
Thank you, Your Honor.
Hearing. And Mr. Gilbert, do you know how she wishes to proceed?
Yes, Your Honor. Her and I talked yesterday, and she wishes to plead guilty to not reporting.
All right, Ms. Heard, would you, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help God?
Yes, sir.
Put your hand down. Ms. Heard, you understand you have the right to have a probation violation hearing with the assistance of a lawyer and to question the evidence presented against you and to present evidence in your own defense. You understand those rights?
Yes, sir.
You're on probation for possession of a controlled substance on a 7411 deferral. If I find you to violate your probation, I can revoke the deferral, can revoke the probation, and the maximum penalty is 2 years in prison. Do you understand that?
Yes, sir.
You'd have the right to the hearing where the prosecutor would have to prove that guilt by a preponderance of the evidence. Do you understand that?
Yes, sir.
Has anybody promised you anything in exchange for your admission?
No, sir.
Has anybody threatened you?
No, sir.
Is it your own free choice?
Yes, sir.
Knowing all this, how do you wish to plead to violating probation? Guilty or not guilty?
Guilty.
So, Ms. Heard, were you on probation to this court on a 7411 for possession?
Yes, sir.
And as part of that, were you required to report to the probation department as instructed?
Yes, sir.
Did you fail to do so back in October of 2025?
Yes, sir.
And then did your failing to report extend for at least a 60-day period?
Yes, sir.
Okay. All right, meaning you were failing to subject yourself to supervision for longer than 2 months. Is that right? Okay. Mr. Gilbert, you satisfied with that factual basis?
I am, Your Honor. Thank you.
Ms. Gilbert?
Yes.
Are you aware of any other promises, threats, or inducements, Mr. Gilbert?
I am not.
Ms. Gilbert?
No, Your Honor.
All right, Ms. Heard, I find that I'm going to dismiss counts 2 and 3 and find that your plea to count 1 is knowingly, understandingly, and voluntarily made, And if there's a sufficient reason in fact in law to find that you have violated your probation, and I would make that finding. Mr. Gilbert, any objection to waiving any probation violation report and proceeding to immediate sentencing?
No objection at all. Thank you.
Any objection from the people?
There you are.
Mr. Gilbert, go ahead.
As the court is probably aware, there's other cases pending that my client has to deal with, and we would ask that, and she understands that her deferrals is most likely going to be removed, and she will not get the benefit of that. I really wish she would have. However, I'd ask for the court to consider time served and remove her from probation as unsuccessful.
All right, thank you. Ms. Hurd, you don't have to tell me anything, but you're welcome to. Is there anything you want to say today or no?
Just that I'm placed right back on probation for the county that I'm going through, so.
Well, I hope you have better success there than you did
Yes.
here. Okay. That's up to you, right?
110%. I was the same probation officer. Me and her had a long conversation. I'm due to meet with her tomorrow at 1 o'clock. She doesn't want time to work. I have time to negate my responsibilities as she worded it, and
Okay.
I have a job, so she's willing to work with me, and I have my cases PR bonded
Okay.
with her approval to be able to. That's all. Thank you.
Okay. Thank you. Ms. Goodrich, any recommendations from the people?
Yeah, Sharon, thank you. It sounds like they're willing to give Ms. Hurd a second chance in Ogama County. I hope she takes advantage of that. For this case, I would ask for the 7411 to be revoked and her discharge is unsuccessful with credit for time served.
All right. Well, Ms. Hurd, if you were, I mean, your compliance with probation, to me in this case was really terrible. And so if you were on probation to me for a higher level felony crime, you'd be looking at some serious jail time or maybe even prison. So I hope you comply with probation down in Ogama. But what I've got you on probation for is possession of Xanax. So we're not gonna send you to prison on that with no prior felonies. So I will find that you have not complied with the deferred status or your probation. So I'm going to revoke the 7411 status and revoke your probation and discharge you as unsuccessful from probation. So then we're going to enter a judgment of sentence on that felony possession charge. There's $68 in state cost, $130 in a crime victims assessment, $350 in court costs, and $60 for DNA testing fee. That'll remain due and owing in the amount of any unpaid balance. And I'll order that you serve 64 days in jail and give you credit for 64 days that you've already served on this violation and on the initial arrest. So because we are entering that judgment, I'm not going to continue on probation. So as soon as we get that paperwork done, you'll get released. You'll have to make arrangements to set up a payment plan to take care of these fines and costs.
That's part of my court case on there. Since she's is the same probation officer and knows what had happened and knows that I'm the one that is signing her, she has it set up to where I have to have that as part of an agreement to be able to pay this and clear 4 cases and show that I'm making progress. To do outpatient, at least we have outpatient services.
Okay.
Due to being a heavier
Okay.
felony.
Because we are entering the judgment, you can appeal if you wish by filing an application. So we're going to hand you a piece of paper explaining that and ask you to initial 1 copy for us so that we have a record we gave it to you. It's about your appeal rights. If you want a lawyer, you'd have to ask me within 6 months. Where'd you get that?
It's on jail meds.
Oh, okay. She's allowed to have that. Okay. All right. I just see her pull a pen out. I wanted to talk about it. All right. And the other one is for you to fill out if you want to file an appeal. Okay. Good luck to you, Ms. Hurd.